you all join us. The topic for today's session is Beyond Litigation, Career Opportunities in Institutional Arbitration and Online Dispute Resolution. As we all know, litigation is no longer the only or even the most dynamic career path for legal professionals. With the rapid growth of institutional arbitration and online dispute resolution, new and exciting opportunities are emerging that combine legal expertise with innovation, global reach, and technology driven justice. And that's exactly what we are here to explore today. This webinar has been designed to introduce you to these rewarding legal careers that go far beyond the traditional courtroom and to inspire you to think about how you can shape your own journey in this evolving landscape. Now it's my privilege to introduce our distinguished mentor for this session, Advocate Mr. Syed Mohammed Tayyab sir. He is currently the Secretary General at ODR Nexus, which is a leading electronic alternative dispute resolution institution. He has served as the Deputy Registrar at SAMA, which is India's foremost online dispute resolution platform. He is a certified arbitrator by the Indian Institute of Arbitration and Mediation with deep expertise in arbitration under the procedural frameworks of the Singapore International Arbitration Center, the Hong Kong International Arbitration Center, the London Court of International Arbitration, and the United Nations Commission on International Trade Law. His journey from institutional roles to leadership positions reflects his deep commitment to accessible justice, legal innovation, and procedural excellence. He has earned a widely respected name in the ODR and arbitration ecosystem, both in India and abroad. And with this, we are honored to have him with us in this evening to share the insights and guide us through the exciting world of institutional arbitration and online dispute resolution. So without further ado, let's begin. I now invite Advocate Mr. Syed sir to take forward and guide us through.
Hello everyone, and thank you for that very generous introduction. And I almost did not recognize myself for a second. So thank you so much. Good evening, everyone. So as you all know about the today's topic, which is career opportunities beyond litigation, and especially really related to the field of arbitration and in institutional arbitrations, what are the career opportunities, and particularly in the field of online dispute resolution, which is a very emerging field right now, not only in India, but also in the global arbitration landscapes. So it feels really special to be here with all of you, the future legal minds, because I see you that we are not just lawyers, we are just like a policymakers, we are innovators in the new justice system, and we are leaders in this particular law field. Whenever some student try to study law or wanted to pursue law, as in my case also, so I was only aware about two professions after completing the law. We all know that whenever we think about the lawyers, we feel we can imagine that there is a man or there is a woman in a black coat in the court fighting for the justice, and we only know about there is a judicial examination option or the litigation option. Most of the students don't aware about that law is far beyond the courtrooms, and law today is much bigger than what we are thinking about and what we thought when we get into the law school. And that's where I want to take you today, into the world beyond litigation, beyond the judiciary, especially institutional arbitration and online dispute resolution. So every time whenever we talk about arbitration or dispute resolution or the institutional arbitration, so then the traditional lawyers will think about that the dispute resolution professional is coming here to snatch their bread and butter. But that's not the case. Why we don't think like dispute resolution, the private dispute resolution system and the traditional court setting is a complementary things. They can coexist in our adversarial justice system, where courts are trying to reduce the pendency, and we can also help to lighten the work of our judiciary. At least if we can say the national judicial grade data, then there are almost 5 crore cases are pending before taluka level court, from Munsif court to the Supreme Court of India. And that's a matter of very big concern. If we can start trying to reduce the pendency of the our court, which is on today's date, then it will take around 300-400 years to complete all the pendency. So then the dispute resolution or the private mediation centers or the private ODR institutions came into existence. So basically, my basic idea is that I am working in this particular field since my fourth year of law, and I have completed 5 years in the last month in this ODR sector and arbitration landscape. That it's not easy to lighten the word of our judiciary. It's like an impossible task, and we should we should take a realistic approach. We should not be like idealistic that okay, arbitration institutions are here to lighten the burden of our judiciary, and we can vanish we have some type of Harry Potter band, and all the cases will be vanished from the courts. That's not possible. So we have to talk about like a realistic approach. At least we can try to divert the traffic of cases which are going towards the court. That doesn't mean if there are 5 crore cases are pending in the courts, in every day there are lakhs of or thousands of cases are filing every day in the district level, in the High Court, in the Supreme Court also. So why we can't divert that traffic to the private mediation institutions in the compoundable cases, in the civil nature of cases, not the criminal cases where the punishment is required or where some penalty is required. So at least we can try to divert that traffic to the private institutions in the pre-litigation stage only. And if we will able to get success in this particular mission, then our courts have enough time to settle those disputes which are basically pending in the courts since last 30 years, 35 years or 40 years maybe. Because we all know that in the civil nature of these disputes, on an average, it will take 15-20 years to dispose of from civil court, and sometimes first appeal, second appeal, and then go to Supreme Court also. So it will take around 20-25 years approximately. And we all are working for the clients. Either I am working in the dispute resolution field, either you are working in the litigation field. We are only working for the clients. We are here for the clients. And if there are no clients, if there are no cases, then we can't get success in this particular field. But then if 15 years, 20 years are taking in this particular field, then clients are frustrated. Businesses are suffer, and justice that get delayed. And it's a very famous quote that justice delayed is a justice denied. When I have a decree in my hand from the civil court, and that's a very sad situation that I was in a Saket court and last year, and that particular guy was very happy that his partition suit was succeed. But he told me that his father filed that case 15 years ago and he is no more right now. That's the dispute between the brothers of his father and between his father, and he got the decree. He got the decree in his favor, in his father's favor, but his father is not alive. So what's the ऐसी जस्टिस का क्या फायदा? केस हम फाइल करें, 15 साल बाद उसमें हमें न्याय मिले. That's why these private dispute resolution centers, mediation centers, arbitration centers came into effect. This is where alternative dispute resolution comes in, not as an alternative anymore, but as the mainstream. I always say that we are not an alternative dispute resolution system. We are like on the same boat. I am just working on the commercial matters. I am just working on the cases where Supreme Court says that there is a mandatory mediation will be there, like Section 12A of the Commercial Act. Supreme Court says that there should be a mandatory mediation before coming to the court. So why I will not try to settle those cases before going to court? And we also think that settlement is like a negative thing. Like I was in a matrimonial dispute where the dispute in between the spouses, and they want divorce. They were very adamant that they need divorce and they don't want to live together. And then my mediator, I was assisting her. She's a Supreme Court senior advocate also, Sangeeta Malhotra. She told me that day, in cases in mediation, that doesn't mean that always we can try to settle the dispute between the party in the way that they will start living together. If parties will reach amicably towards the divorce, that's also a settlement. That's also a successful and success of mediation or success of ADR landscape. And we always think about that. If we want to settle the dispute, then हम कोशिश करते हैं husband wife साथ में रहे, अच्छे से रहे. That is not settlement. That is not mediation. If there is something like they will get amicably divorced without going to court, where they have to spend 5 years in the court, in the legal battles, and spend so much money, there is no need of all this. We can sit on one table, we can try to negotiate, we can come with our proposals. They will give, other party will give the counter proposals or accept that proposals, and we can make a amicable settlement agreement, submit to the court and say we want divorce. We have to go that particular mediation center, and now we are ready on these terms and conditions. And cases, courts will agree on that settlement agreement. So that's why ADR landscape is very important, because that's cost efficient. That's not time consuming. In my initial days of the ODR sector, when I joined ODR as a case manager in my fourth year of law, I saw that cases are settled in one sitting. Are settled in only 2 meetings. And every time I see, there is something like an ego clash between the parties. There is a communication gap. And if we, as a lawyer, if we are a legal professional or a dispute resolution professional, are able to reduce that gap in communication between the parties, then there is no dispute. And when we reach to the court, that gap will not reduce, but despite reducing, that will increase automatically. Then our ego will clash again. Our ego will say that why you will go to court. Now I will file a counter FIR or counter cases against you. Law is for the people, and law is a tool to make society a happy place, a very good place to live for the betterment of the society. So why we don't adopt this ADR or ODR sector? So that's why ODR is coming. ODR is coming in the existence. And then there is an institutional arbitration also. There is institutional when arbitration came in India, the first act in 1940, and then accordingly the landscape and will develop, and new acts will coming. The 1940 acts totally repealed, and 1996 act, which is still working and in our Indian legal adversarial system. We see that there is only option of ad hoc arbitration. If there is a dispute, and if I want to appoint arbitrator, if I want a settlement, if I don't want to go to court, still I need to go to court to appoint the arbitrator in Section 11 of the Arbitration Act. So we are not like on the same page like the international standards are working, like LCIA, like Singapore International Arbitration, like Hong Kong International Arbitration Center is working. We were not on the same boat. We need to go for high court for the appointment in domestic dispute, and in international dispute we need to go to Supreme Court. That's literally a major concern still in our legal and arbitration landscape. Then whenever there is an ambiguity in the dispute resolution clause, either your arbitration clause is very clear that if the dispute will be arises, I will go to that particular institution, or I will appoint this particular arbitrator, and both the parties if sign that agreement, that is valid. But if there is ambiguity in the dispute resolution clause, we need to go to Supreme Court or High Court. as the case may be. But then there is something like institutional arbitration, which have their own rules, own standards, own administrative procedures. They will handle your case with utmost care. They will not like this ki, you have to wait for a year or a year and a half to complete that arbitration proceedings. Like in the ad hoc arbitration, where the court will try to appoint a uh, mm, retired judge of High Court, retired judge of Supreme Court, or a senior professional in that particular field as an arbitrator. And arbitration in the past has considered as the old boys club of litigation, where we only see that the arbitrators will be appointed the from the group of retired judges, honorable judges, and retired professionals, like everyone maybe who uh, left their like a seniority age, and in the ages of 70 and 80 years old, those people will be appointed as arbitrators. There was bar in the arbitration act also, that if you want to be like an arbitrator in that particular case, you need a experience of at least 10 years. But in 2019 amendment act, that bar has been removed from that particular section. So there is no bar right now. If you are experienced, at least you have 4 or 5 years of experience, then parties will easily agree to appoint you as an arbitrator. Institutional arbitrations is like that. There are so many institutions, like a very famous institution in Paris, which is International Commercial Court, and SIAC in Singapore. In Indians also, there is a Nani Palkiwala Center for Arbitration in Chennai, and Mumbai International Arbitration Center, and there are also like Indian Institute of Arbitration and Mediation, and there are also like some ODR institutions which is working very well, like Sama, like Puzolf, Cadre, COD, ODR Nexus, where I am working right now. The benefits of giving those cases and try to settle cases via mediation or arbitration through the institutional arbitration is like that. You just go to that arbitration institution or ODR institution, you will submit your case file, then you don't need to worry about anything. Because in ad hoc arbitration, you will have to decide the procedure, the case management process, everything with the other party and the arbitrator. But in institutional arbitration, the process of the arbitration, the workflow of the arbitration, the rules of arbitration, the case management process, how the secretariat will work, how the registry of that institution will work, how you will have to submit the case, how you will have to submit the rejoinder and other pleading documents, evidence, and everything, that is already written in their rules. And they are also ensuring that you will get an award within 3 months, 4 months, 6 months, because law says that after on the date of the appointment of the arbitrator will have to pass the award within a year. Otherwise, after a year, his or her mandate will be over. So institutional arbitration is ensuring right now that you will get award in 6 months or maybe maximum within a year. And when we talk about the ODR institutions, they are giving you award in 90 days. They are settle your cases in mediation in 30 days, 21 days, 7 days, because they are online dispute resolution platforms. They will try to contact the parties via online mode. You don't need to go anywhere. You are in Mumbai, I am in Delhi. My mediator is sitting in Chennai, but we are on the same boat. We are on the same page. We will try to negotiate. If we will agree on the same terms and conditions, settlement agreement will be made, and parties will sign electronically. Agreement will be made, and also uh, whatever, if there is a financial dispute, you will get your money. If there is some other matrimonial dispute, accordingly that case will be settled maximum in 30 days in the mediation and conciliation, and in arbitration you will get award maximum in 100 days. Even in the cases when you go to court, sometimes you don't get a hearing date within 1, 2, or 3 months. your case has been filed, you have to check every time with the registry, and then your case will be mentioning, then notices will be served, then other party will come, then other party asks the time, everything. It's like take at least a 6 month when the pleadings will be filed, then the trial will be start. But in institutional arbitration, they will, if you go to an institutional arbitration and other party will agree on that institution, that means they agreed the rules of arbitration and mediation and the process of case management. They are agreeing that they have to submit pleadings in 10 days. They have to submit a statement of defense in 10 days, 15 days, then rejoinder will be filed, then if need, evidence will be filed. If that oral hearing will be need, then hearing will also be conducted. But in ODR sector, oral hearing is almost not conducted in any cases, unless and until any parties will required or ask for a one oral hearing from the arbitrator, or arbitrator thinks that there is a need of some more clarification before the side of the party, then oral hearing will be conducted. And in ODR sector, the arbitration will totally conducted as per the section 29B, which is talking about the fast track arbitration. And fast track arbitration is saying if parties are agreed, that will be a totally a documentation based arbitration. There is no need of hearing. If parties will be agreed, you will submit your documents, I will submit my documents. If arbitrator is okay, parties are okay, then I will make the award as per the documents which is on record at the time of passing the award. If there is some confusion, some clarification needed by the arbitrator, then oral hearing will be automated. They will conduct a oral hearing accordingly. So that's the very uh, basic requirement of today's. Because if I want to go to court, I have to file submit a court fees. Then I'll have to make documents. Then I'll have to give hefty fees to the lawyers. And then if everything will be okay, then I'll get a date within 2 or 3 months. Then case will be start, and it will take around 3 years in criminal cases, 5-10 years minimum in civil cases. So that's why institutional arbitration is like a mainstream thing in today's world. And as a lawyer, there are so many opportunities to work there also. When I joined Sama, that was just a startup. They started from Kolkata only, and I was joined, and then we start working on a full-time arbitration thing, mediation thing. So I was like also very anxious about my future, because I was working like beyond something which nobody knows. If I am talking about talking to someone that I am working in the mediation sector, they heard that I am a meditation trainer or something like that. But people were not, even so many lawyers from a district level who is working in municipal court or a civil court, they don't know about what is mediation and what is arbitration. So we need some type of legal awareness in the society also, that what is arbitration and what is mediation. And there is so many opportunities, not only in India but also in a global landscape. My classmate is working in Dubai International Arbitration Center. One of my friend is studying in National University of Singapore, which is very famous in LLM in arbitration, international arbitration. And there are so many people also who are working very good, not only in India but also in other countries, which is very famous for their rules and laws of arbitration, which is like we can talk about Paris, which is known as Makkah of arbitration, and other institutions also. People are excel in this particular field. There are some roles also in the ODR sector and institutional arbitration, that this is something not like कि after joining institutional arbitration आपका law छूट जाएगा. I was also anxious in my initial days of career that यहाँ तो law का काम नहीं है. ODR is like a legal tech company. आपको जितना रूल आपका लीगल में है, उतना आपका टेक्नोलॉजी में भी है. आपको फ्यूचर्स, नए नए फ्यूचर्स के बारे में बताना है कि किस तरह से आप अपना आसान टेक्नोलॉजी के जरिए आप काम को कितना आसान कर सकते हैं. बिकॉज ओडीआर सेक्टर इज वर्किंग ऑन अ बल्क मोड where every day some bank is coming and filing 1,000 cases in one click. Then we appoint arbitrator by just clicking 2 3 tab. Documents are uploading in a bulk mode. Pleadings are filing in a bulk mode, which the work which my clerk or the registry of any court will take time for a month or 2 months, ODR is taking only a day. You will file a case in just a click. My maximum limit while I was working in my former with my former employer, I filed around 50,000 cases in a day without any hectic schedule or without any frustration. That's the ODR. That's the power of the technology. And ODR is not like something alien to our society. That's like a combination of legal and combination of tech with the ADR sector. Because ADR institutions are nothing. They are just like a private courts. You will get the award, and after that you will go to the court for execution. If the award is consent, you don't need to go anywhere. If that award is consented, there is a dispute between me and the other party for filing of some like 30 lakh rupees. I'll agree that I'll pay 30 lakh rupees. I'll agree on 25 lakh rupees, and I'll say that I'll give in 2 installment. I agreed. This is a consented award. I don't need to go anywhere. But if I am not consenting on anything during the proceedings of the arbitration, then the other party need to go to the execution process. And arbitration is all about the procedure. Arbitration is all about the fairness. If your process is okay, no court in this world will like set aside your award. If you have your institution or your arbitrator follows the principles of natural justice and policy and principles of fairness and integrity, no one go to the reasoning part and check whether arbitrator is applying their legal mind or not. That's not the domain of the court. Courts only see the procedure of the arbitration. If procedure is okay in the appointment process, in the proceedings, then award is okay. You will get award in 3 months. After 3 months, that there is a cooling period of 90 days in section 34. Then after completing 90 days of that cooling period, then you will directly go to that concerned court. In major cases, that's a commercial court or a district judge court in the district, or in some states like Rajasthan and other states, you will directly go to High Court for the execution of the arbitral award. Then you will get what you want within a year, max to max within a year. You will get award in 3 months. After cooling period, you will file the execution petition. After 1-2 hearing, you will get what you want, what is written in the arbitration award, unless and until your process is not faulty. If your process is okay, you followed all the principles, there is no issue of patent illegality and anything like this, then you will get what you want. It's a very simple process. It's not like that something very big. You have to file the documents, and even in the ODR sector, parties don't come with lawyers. Parties file their pleadings individually. Parties don't need to hire any legal professional. Even the secretariat of the institution help them to file. They don't say ki what you will write to this particular response or reply or rejoinder. They support in an administrative way. Okay, in this format you will submit your reply. In this way you will submit your rejoinder. In this way you will come to the tribunal and submit your response in oral way. They will not talk about whatever you want to write in that particular reply. And arbitration and ODR is like a boom for the banking sector, where the default rate is like a 55% default rate in credit card. Currently in India, there are 55% to 60% default rate in credit cards, and credit cards is totally an unsecured product, where Supreme Court and different high courts have already said कि you took this risk, then don't come to us. In unsecured loan, courts are not able to do anything. In that particular case, cases are already NPA, non-professional asset. Then bank tries कि whatever they will able to get, they will try to recover. This is very cost efficient process also. Where ICICI Bank is spending a 60,000 in one particular case, they are right now spending only 1,000 rupees in one case. But in 2019, back in 2019, they were spending around between 45,000 to 60,000 in one case in the court. But now they only need to spend only 1,000 rupees in one case. So ODR is cost efficient for NBFCs, for bank, for finance companies, especially for the BFSI sector, and also for the individual parties also. Like there is one example. There is a property dispute between two brothers. One is sitting in some state of United States of America, and the other brother is sitting in Maharashtra. And after 2-3 video calls or uh, normal calls, our arbitrator were able to settle the dispute. They don't need to go anywhere. That brother who is in US, he was so anxious he needs to come to the court in India, and then so much time will be like waste for him. So that's why ODR is like very much need of the society and need of an hour. This is not like an alternative process. This is not like a future. People are saying that ADR is a future. No, ADR is not a future. ADR is a now thing. We need ADR currently because there is so much pendency. I don't want to go to court. I started litigation in last year also in 1 or 2 cases, and that was the last time I went to the court. I was like, no, this is not a place for mine, for myself, and this is something like very frustrating situation in the court. We are preparing for cases all night, and our case were not take up on the board. So that's why we need to adopt this arbitration, conciliation, mediation via the ODR institutions. And we live in a digital first world where we can order whatever we want. In just 1-2 clicks, we can order on Swiggy and Zomato, and our food is on our table. We can order a cab. We can book a flight. We can order anything, any clothes or anything, whatever we want. Then why don't we need to settle our dispute through a online mode? We need to trust on these institutions also. They are working very well. They are very neutral. They are not working for any party. They are just trying to settle your dispute from the comfort of your homes. You don't need to go anywhere. You don't need to shut your shop to go to the court. If you are a housewife, you don't need to go to anywhere. You just need even a normal mobile. You can settle your dispute. You don't need to spend more money. You don't need to hire a legal professional. That's why ADR is in Indian legal landscape. ADR is very, very necessary right now. And there are so many career options in ODR sector also, that if you are a law student, then there is a position called as case manager or tribunal secretaries. So case managers in the mediation cases, where you can assist the mediator in overall proceedings in only an administrative way. That I assign you some cases. You can inform the parties that some type of case is filed against you in a loan dispute or whatever that particular case. You will inform the parties and you will try to convince them, tell them about the benefits of the online process and take their consent. If parties will be agree, then you will connect those parties to the mediator. You will record their arguments for the purpose of only vetting the or writing or drafting the settlement agreement, because mediation is a very confidential process. So you will working like a shadow of the mediator. And to be very honest, whatever you will learn in this process, no court or no lawyer will give on hands experience on this particular field, because you are working beside the judge or a mediator or the arbitrator who has a very good experience in this particular field. You are talking to the parties, then you are briefing to the mediator, and then mediator will talk to the parties and then try to settle the dispute. And then you will also, if your mediator will be ready, you will also assist him or her in making of the award process or the settlement process. Tribunal secretary is like a very not a technical but a legal post. That's a very famous term in all over global landscape. You are a secretary to the arbitrator, you are a secretary to the tribunal. You are the person who will ensure that documentation is filed by both the parties on time. You are the person who will ensure that arbitration proceedings will go accordingly, without any delay, without any delay and without any biasness. You will try to uh, uh, you will try to get all the documentation from the parties, file on the platform, and brief the arbitrator before the hearings. You will also draft the procedural orders, whatever orders will be go during the proceedings. You will have to draft the orders, then the arbitrator will be vetted down, and then those arbitration process will be that orders will be passed. So as a tribunal secretary, there is a very good chance to learn in and out about whole arbitration process. I was working for 2 years as a case manager and tribunal secretary, not only in the ODR sector, but with also the retired judges in the ad hoc arbitration also, where the arbitrator was appointed by the Honorable Rajasthan High Court. So I learned a lot from that particular retired judge, who is also my mentor, and in the ODR sector also, because you are seeing how parties submit their pleadings, how the counsels are working in the arbitration, and how the arbitrator is applying his legal mind in the process and drafting the award. So you will get the full on experience from the side of from the perspective of the parties and from the legal mind of the arbitrator also. So that's a very good opportunity if you are a lawyer. So after from the second year onwards, if you are in a 5-year law degree or a second year law degree, you will working you are eligible to working as a case manager and a tribunal secretaries in the ODR institutions. And there are so many internships also coming from the Singapore International Arbitration Center, Hong Kong, ICC in Paris, LCIA, and some other institutions also. I am forgetting their names. They also take tribunal secretaries or interns on a virtual rolling basis from the pool of those students who completing their first year or the second years and who is still students in a law school. Then there is a very good question always arise that there are so many opportunities for the law students, but what the lawyers do in this particular landscape. So if you have an experience of at least 2 years after your law school, you will be act as a mediator in ODR institutions and tribunals, online ODR institutions or ADR institution. You will act as a mediator, because there is a bar in past that you need at least 5 year or 10 years experience as a mediator and arbitrator respectively. But now there is no bar. Then if you have a good experience from any sector, not a legal sector only, then you will act as a mediator. And if you will have a good experience of at least 5 years or 4 years, then some ODR institutions will take you as an arbitrator also, and they will appoint you arbitrator in the cases. So lawyers have very good opportunity to working as an arbitrator and a mediator in the ODR institution, and that's like a freelancing work. That's not like you left the court. You don't need to leave your court practice, or don't need to leave your job. If you are working in the corporate sector, in litigation sector, or in-house counsels also, if you have not signed any non-compete agreement with your employer, then you will able to empanel before these ODR institutions, and you will get a good number of cases, and you will easily earn a good handsome amount from these institutions on a day-to-day, on a or a monthly basis. So this is the space where law meets technology, and it's not like something alien. It's only going to grow. There is a very famous institution in Hong Kong which is known as eBram, that is totally working on an online model. I am also empaneled as an arbitrator there in eBram online dispute resolution. If you have a good experience, you can get a hands-on experience from international arbitration arbitral institutions and ODR institutions in India and abroad. Many students and the professionals always ask about why this matters for you as students. Litigation will always remain important, because we are coming, most of the people are coming from the traditional law universities, where we didn't get any good opportunities to excel in the legal internships and other forums. So we have very less number of chances to get appoint or get job in any corporate sector. Then that's not like a very bad thing. We have the other options also. ODR is one such option, because businesses today prefer faster, cheaper, and confidential dispute resolution. They don't want to spend their whole year in the court. They have some other work also. Their legal teams are working on compliance or other things also. So why they need to go to the courts? Government policies are pushing arbitration and ODR. Yesterday only the Indian Army launches their arbitration platform. I was very shocking to see that tweet from the ADG of the Indian Army, that even our army is adopting the arbitration in the construction disputes between their engineering construction board and the contractors and investors. They build their own ODR platform, because that's a government sector. The government sector basically adopt or make their own platform to settle their disputes. Courts are adopting the ODR institutions for the conduct of Lok Adalats in Bihar, in Rajasthan, in Madhya Pradesh, in even Maharashtra. I was working as a state coordinator with state legal service authorities and the national legal services authorities. There are, even in very shocking and very astonished thing also, police, we conducted a very good police mediation project in Madhya Pradesh for a six month long period, where on the cases which are against the women. So whenever any domestic violence case, or whenever any cases related to matrimonial or family disputes filed in police thanas of Madhya Pradesh, then the thanas will send those cases to us, and giving us a 7 days time to try to settle the dispute via mediation. Because in most of the times there is some very small issues between the spouses and the family members. So in the 6 months, they filed around 4,995 cases. I know the exact numbers. And in those cases, we get around 40% cases were settled successfully. These are the cases before the FIR has been filed. And in those cases which were not settled by us, then police have filed the case, the FIR after that, after the unsuccessful mediation. But we tried to settle the dispute before filing the FIR, because whenever FIR has been filed in the matrimonial or disputes between the spouses, then there is no chance of reconciliation, or a very less number of chances of reconciliation. Then we try to settle their disputes, and we were successful. 45% cases were successful in MP. And we conduct that mediation process 2 years simultaneously in 22 and 23. So that's a very big win for the arbitration landscape or ODR landscape, that even government projects, Ministry of Consumer Affairs built their own ODR platform. Many high courts taking help from ODR institutions for conducting lok adalats. And that's all because happened because the lockdown, when even the justice is not served by the traditional method, then ODR is come into existence. And global legal market is also shifting, and India is becoming a hub. There is some reservations on this topic that India is becoming an arbitration hub from my side. But yeah, still we are trying to settle the case. We are trying to helping the businesses on a very faster way, on a very very efficient manner. So yeah, learning about institutional arbitration and ODR gives you an edge, not just as lawyers, but as innovators of justice. Excuse me, can you please give me a minute? Sorry for the inconvenience. So learning about institutional arbitration and ODR only gives you an edge, not just as lawyers, but also as the innovators of justice. In this sector, there are only a young people are working right now. And young minds are very capable, and they are trying to reduce the burden of our judiciary, which is like overloaded. We need a 400 years or 500 years to settle and clear those pendency. So we as a justice makers, we as a innovators of justice will try to divert the traffic which is going towards the court. Even when I started, I too thought litigation was the only way forward. But by working in the arbitration institutions, I discovered how much impact you can make behind the curtains, ensuring cases move seamlessly, awards are delivered on time, clients are updated, arbitrators are trained, and justice is accessible. So Niti Aayog also published a report in 21 or maybe in 2020, and they were trying to say that we have to adopt a ODR, online dispute resolution system, in India. And their ODR book, that particular policy published by Niti Aayog, is only based on the ODR. Justice Sri Krishna report, and all they give the citation of Justice Sri Krishna report and other reports by the retired Supreme Court judges and other legal luminaries in this particular field. So they are also trying to adopting and saying that we can adopt this particular arbitration field or ODR institutions. Even the recent example of Indian Army, which built their own ODR platform to settle their disputes or arbitrate their disputes in construction matters. ODR opened an even bigger door for everyone. You are working with corporates, you are resolving cross-border disputes, managing technology-driven platforms. Today, if you can try to combine law with innovation, then you will able to make change in the society. In ODR sector, everyone has a simple mission: access to justice for all. How can we reach to the people who is living in a very remote area of India? That lady or that man needs at least spend 1 hour or 2 hours to reach to particular court to just check the status of their cases. Then why don't we need to adopt? Even we are very happy to order foods on Zomato and Swiggy, and we can adopt cold drinks and ice cream on Blinkit and other e-commerce or quick commerce companies. Why we can't adopt the ODR institution to settle our disputes? People are working. I am also working. This is a very young field for the Indian people, and there is uh, people need time to trust on these institutions also. But if we can look beyond the courtroom for the law students, basically, if you can focus on your ADR elective subject. In many of the courses, ADR is a very in law schools, ADR is selective. In some law schools, that is compulsory subject. You can explore more about that ADR subject. You can try to do internships in the dispute resolution team. Every law firm has a dispute resolution teams which can handle the arbitration and mediation and these types of private commercial cases via arbitration and mediation. Then you can understand about ODR platforms, ADR institutions, physically and online method. You can also try to build your skills in drafting, negotiation, case management, and technology. So you will get hands-on experience on everything in under one umbrella, which is known as ODR, which is known as ADR. Because the future of dispute resolution is in India and globally is not just in crowded courtrooms, but in institutions and digital platforms that deliver justice faster, better, and smarter. And this is true. Many institutions in our Asia Pacific region, Singapore, Hong Kong, China, they are totally adopting the ODR landscape. And if we can working well, then who knows, some of you here may become the next leader of this landscape. So we can think about this, the career opportunities beyond the courtrooms, beyond the areas, beyond the litigation sector. So yeah, that's all from my side. I can speak a lot. If you have any questions, so I'm open to answer your questions.
Hello, sir. Am I audible?
Yeah, hello.
Hello, sir. Sir, so I have a question. When you started interning during your 4th year at law school,
Yeah.
sir, like what were the skills they take when you are applying for a firm specialized in ADR?
So basically, as such, there is no such legal skills need to be needed by the ODR institutions. If you are good in communication, if you are good in managing things, if you are good in somehow simple drafting, not like a legal rigorous drafting, then you are eligible to working in the ODR institutions. They will train you basically. So in ODR Nexus also, we have we have openings for tribunal secretaries and case managers. After you will applying for that particular tribunal secretary work, then we will give a training, hands-off training about how you will need to work and how you will be active in this particular field. So there is no such skills needed. You just need and you have a very good communication skill, then you are eligible to apply in this particular field.
Sir, I have another question now. Yeah. Like in law schools, we get maximum of 1 month of internship in summer breaks and 1 month of internship in winter break. So
Okay.
that's total 2 months every year. But sir, are the ADR firms like after college, like after evening, if we can go to the chamber or the firm?
So I'm not I got your question. I'm not aware about the firms. You are talking about the firms,
sir.
but ODR institutions are tribunal secretaries need to spend only 2-3 hours a day in ODR institution, and it is totally online. You came from your law school at 4 p.m. and then you will check whatever you need to do. You will complete within 1 and 2 hours. Then your work has been done. So I was working. I was a 4th year law student. I need to do my work also, my college assignments, exams, vivas, and everything. And I was working very well. So it's everything about the management, how you manage your time, and they will totally okay to take you on board if you are going to law school also.
Okay, sir. So, and lastly, this is a request, sir. Can you, sir, mention some of the good ODR firms?
So ODR institutions currently, if you are talking about the international level, that there is a very good ODR institution which is known as EBRAM ODR institution in Hong Kong, and that's a very good ODR institution, totally working online. You will also have to work from India if you will able to manage the time difference between Hong Kong and India. And if you are talking about India, then there is SAMA, a Bangalore-based institution, Resolve, a Mumbai-based institution, ODR Nexus, which is a Guwahati-based institution, and ODR Nexus headquarters is in Noida, and I am sitting basically in Noida only. So these are the good institutions where you can work as an intern, tribunal secretaries, case manager on a part-time basis.
Okay, so that's all from my side. Thank you so much, sir.
Thank you. So yeah, if you working as a tribunal secretary, someone asks how to get ODR internship. So you can check time to time Lawchemy. There will always they publish the internships about ODR sector and other legal sectors also, and you will check these ODR institutions LinkedIn pages also. They will post there also if they need any particular opening for the internships. And someone asks that does we get participation certificate too? Yeah, absolutely, absolutely. If you are working with any ODR institution, you will get tribunal secretary certificate when you work alongside with the tribunal or you work as a case manager. You will get certificate at the end of your work. And basically, tribunal secretary and case manager is not an internship. You can work for a 1 year, 2 years, and whenever you need certificate, they will give you a whole certificate of a year that you work there from 1st July 2024 to 30 June 2025. So you will easily get certificate on just a very normal request.
Sir, I have another question. Sir, after graduating to become an arbitration or ODR specialized lawyer, do we need to first practice as an advocate, or we can just get into the like we can just start as an arbitration ODR lawyer or arbitration specialist?
So there is a difference of opinion and vary from person to person. I never
Yes.
go to court. I started practicing arbitration and mediation from direct from my law school. Even when I was in the 4th year of law school, and just after completing my law in June 2022, I joined full time as an ODR professional in July 2022. So I never go to court. I don't have any litigation experience, and I am working very well. So it's only up to you how you can learn from the
Handle
this
it.
particular landscape.
Okay.
So yeah, Gia, you can check whether someone has any other questions. Have any other questions, or if not,
Thank you so much, sir. Any more questions from the participants? Okay, so with that, on behalf of Lawchemy, I extend my heartfelt gratitude to our esteemed mentor, Advocate Mr. Syed sir, for taking the time to guide us today. Your words have truly shed light on the evolving landscape of legal careers beyond litigation and the opportunities that institutional arbitration and online dispute resolution holds for young professionals. I also want to thank every participant who joined this evening. Your presence and engagement have made this session really meaningful. We hope you found that discussion valuable and it will help you explore new pathways in your legal journey. A special thanks to the team of Lawchemy for organizing and making today's session possible. With that, we formally conclude today's webinar. Thank you once again for being with us and we look forward to meeting you in our upcoming sessions.
Also, there's an instruction for the participants. Everyone who has attended the session for more than 40 minutes shall write a review of the webinar to get the e-certificates. Thank you. Have a wonderful
Thank
evening
you.
ahead.
Thank you, everyone.
Thank you.